Welcome to the introduction of the Federal Evidence app. This app will allow you to determine the admissibility of any piece of evidence. Just answer the questions and the screen will light up green for admissible and red for inadmissible. You see the app has nearly 1,500 screens behind the program that guides you through the federal rules of evidence. The app has two basic methods of analyzing evidence. The first is responding to objections. The second method is the Move to Admit button, which allows you to predetermine the path to admissibility. The Objection button has 18 basic objections, which we will discuss in more detail. The Move to Admit button allows you to predetermine the admissibility of evidence. And then, of course, we have a Case Law button, which will guide you to case law relating to each of the rules. Once you touch the Objection button, it will take you to the screen containing 18 basic objections. Under each of these objections, there are over 150 different sub-objections that can be made. As you'll see here, this is character evidence, competency, extrinsic evidence, form of the question, hearsay, improper impeachment, inadmissible evidence, knowledge, memory, opinion, prejudicial, privileged, rehabilitation, relevancy, speculation, and outside the scope. Let's take an example of a felony involving a dishonest act or a false statement. The Objection button is pushed. Next, improper impeachment is pushed. Prior convictions is then pushed. And the first question is three categories. Let's say you pick sentencing has not occurred. It would not be admissible. So instead you choose guilty plea with sentencing. Now you have several options. Let's assume you pick punishable by more than 1 year, and you determine the court can determine it's a dishonest act. You next determine that the confinement date was less than 10 years ago. Then the evidence would be admissible as the screen lights up green. Let's take a walk through the hearsay rule. Say is there an objection? Hearsay. And let's say that the statement is offered, it's a written statement, out of court, and there's the rule number you can check to confirm the rule. Let's say it's a written statement out of court, or an oral statement out of court, and the statement is offered for the truth of the matter asserted. Let's say it's not a statement by party opponent, which would be the first analysis in the hearsay rule. It doesn't fit any of these exceptions, so you'd touch none of the above. That brings you to the 23 hearsay exceptions plus the residual example. And for the sake of our argument, let's say none of those apply. But if you tried excited utterance, you would then answer these questions, reconfirm the rule, determine whether it was made while under the stress of excitement for a green screen. Let's back up, and let's say you say, nah, excited utterance doesn't work. You push none of the above. Now you come up to Rule 804, which, if the witness is unavailable for any of these reasons, gives you more exceptions. And let's say you decide, well, maybe the dying declaration may work. You can touch base with the rule, touch dying declaration. Now you've got to decide what kind of case is it, a homicide case, non-homicide case. If it's a homicide case and you meet this criteria, it comes in. If it's a non-homicide case, dying declarations are inadmissible. And if it's a civil case and you meet these qualifications, it's admissible. And there's the rule you can look at. Let's use the Move to Admit button to see if an excited utterance may be admissible. The first screen that comes up are the four possibilities. The first category would apply, a witness testifying. There's no need to run a competency screen on the witness in this case, so we'd say no. The next screen that would come up would be relevancy screen. Let's assume that it's admissible or relevant, and no need to check that. In this category would be an out-of-court statement. And the statement is offered for the truth of the matter asserted. And there you'll see an excited utterance category. You would press that. and then you would answer the same questions that we had before to determine its admissibility. Let's use the Move to Admit button to determine the admissibility of a text. Again, this would be a witness testifying. No need to run the competency screen or the relevancy screen. This would be a document or a writing. Let's say it's the defendant's text in this case. And then we would press the text button. The next thing we determine, do we want to run the hearsay screen? In this case, we'd say yes. It is a written statement by a party opponent. It is offered for the truth of the matter asserted. It's the party's own statement, and it's offered by a party opponent. You've cleared the hearsay hurdle in this case. Next, authenticity of a text. Yes, we want to run that screen. So we press the text button. And these are methods to determine whether you sent or received the text. These are different factors that the courts conclude that are relevant for this purpose. Let's say the court finds one of those to be persuasive. Now, next you want to run the best evidence screen. In this case, it's an out-of-court writing. You want to prove the contents of the writing, so yes. And you'd press this to determine you want to prove the contents of it to be true. And is it an original writing in this case? And it would come in, and there's the rule to confirm. Let's use the Move to Admit button to see if you can impeach a witness with a learned treatise. In this case, competency is not an issue, nor is relevancy. No need to run those screens. This would be under impeachment. And under impeachment, you'd see learned treatises. And then you'd answer the questions concerning the admissibility of learned treatises. If it's not a learned treatise, then it's going to come up red. If it is, and you've got a concession from either on direct or cross that it's an authoritative source, you answer each one of these screens, and there you get a green for admissible, and there's the rule number. Let's try another one. Let's pretend there's an objection dealing with other acts testimony. So you go to inadmissible evidence and go down to other crimes or wrongs. And then you'd start to answer these questions. Obviously, if you're using it to prove character or conformity, it's inadmissible, red. So you'd have to find another category. The second one isn't going to work either. But if you're offering it for another purpose, then is it one of these purposes? And if it's one of these, you can consult the rule. You're going to get a green light. And depending upon whether it's a criminal or civil case, if it's a criminal case, have you given adequate notice? If you haven't, it's not going to come in. So civil cases are treated differently than criminal cases. And you can back up, and if it's a civil case, you don't have to give such prior notice. You can back up then and follow with the yellow marks what trail you've made. With the Federal Evidence app, you can determine the admissibility of virtually any piece of evidence, and you can respond to virtually any objection that can be made. Good luck and have fun with the program.